Hi, my name is Michelangelo Mortellaro, founder of Mortellaro Law. We have offices throughout the state of Florida, and we assist families with general estate planning needs, anything from last will and testaments to trusts to powers of attorney and healthcare surrogates. We also assist veterans and widows of veterans who may find themselves later in life in need of care, whether that is care in your home, in an assisted living, memory care community, or even a skilled nursing facility. And we also assist with Medicaid benefits, and we are able to do Medicaid asset protection strategies for those folks that need care as they get older, but are technically over the income or asset thresholds to qualify for those benefits. So there are 5 documents that everyone should have when they're over 18 years old. Doesn't matter whether you're young, old, rich, or poor. These are personal dignity choices and documents that you would need in case you ever lose capacity. Now, most of the time when we think about losing capacity, we're thinking about getting older, getting dementia, having a stroke, things like that. But loss of capacity can happen for younger folks as well. Whether you are riding your bicycle down the road and get hit by a car or have a car accident, or even trip and fall while you're walking down the street and have a brain injury. So the 5 documents are as follows. The durable power of attorney, that is for legal and financial decision making if you can't make those decisions for yourself. The healthcare surrogate, which many people refer to as a medical power of attorney, that authorizes you to appoint someone to make medical decisions and have access to your medical records if necessary. The 3rd document is the living will. That is your instructions regarding long-term life support. If you have lost capacity to make your own decisions, the only way to keep you alive is on a machine, typically a feeding tube or a ventilator. And the doctors all agree that you're not going to get better, stronger, and be able to come off of these machines. You want to make the choice for yourself and for your family of whether you would want long-term life support in that scenario. The 4th document in the set is a pre-need guardian. If you ever find yourself in need of a legal guardianship in the state of Florida, you want the authority and you want to take control of selecting who you want to be your guardian. If you fail to do that, it is likely that a judge would simply appoint a stranger, a professional guardian, to step in and become that guardian role for you. So we'd prefer you make your own decisions. And the final, rounding out that set of 5 documents, is the final arrangements document. So do you want burial, cremation, service, no service? We work with families to not only figure out what you want and who would be in charge of those decisions, but we also offer the pre-planning and prepaid funeral services right through our law firm, so we can help you with that. So through Mortellaro Advisors, we can offer those services directly as part of your estate plan. Normally I don't need any microphone because I got a big loud Italian mouth, but today I got 2. So, yes. Anything worth doing is worth overdoing. We're going to have 2 today. All right. So, thank you guys for coming. This is awesome. Great turnout. Appreciate the opportunity. My goal for you guys is to each take home at least one little nugget of information that you didn't know before you got here. And knowledge is power. I see myself as an educator first and a lawyer second, because if you can't get people to understand the concepts of what the possibilities are when it comes to planning, then it doesn't really mean as much. So everything is education first. We'll start off by telling you a little bit about myself and my law firm, what we do, and then we're going to jump right into our topic today, which is the 5 most important documents that everybody should have. And then we'll give you a little taste and teaser of veterans benefits for veterans and widows of veterans that can help you offset the cost of senior care. And we'll give you a little teaser of Medicaid benefits for those folks that unfortunately find themselves in need of things like skilled nursing homes. So, my name is Michelangelo Mortellaro. I am an estate planning, elder law, and asset protection attorney based out of Tampa for the last 18 years, but we currently have several locations. We have Tampa, St. Petersburg. We have Stewart, Martin County across the state. We are waiting if our Lakewood Ranch office ever gets the permit for us to move in. We will be there. They're telling me 1 month, 1 month, 1 month. So hopefully next month is the right one. And then we are actively looking for location in the Villages. That's where all the old people live, if you don't know that. Oddly enough, it is the largest senior, the fastest growing senior community in the world. I won't say anything else about them, but see, you guys know. You know about the sponge thing? Yeah. Everybody's read it. No one seems to have participated, but everybody's read it. So I digress. So we're looking forward to being there as well. So in our practice, we focus on general estate planning needs, so wills and trusts and powers of attorney and all those things that general estate planners do. But we do it with a little bit of a twist, which we'll talk to you about today. We also do VA benefits for veterans and widows of veterans that find themselves in need of care. That care could be in-home care, assisted living, memory care, or skilled nursing. And then we do, again, Medicaid benefits, typically for strictly the nursing home folks. We also do probate. So for anybody who has not planned their estate to avoid the probate process in Florida, then we'll be glad to help you out and take a fee to do it. But part of my passion for education is explaining to people how they can avoid the probate process, because nobody wants to go through it. It just takes time and costs money, and it is unnecessary through proper planning. I always say it's a sucker's game that makes lawyers money, and I probably shouldn't say that because I'm a lawyer who makes money on it. But anyway, I would rather make small amounts of money on a large percentage of people and make sure that I feel good that their assets are going to get to their beneficiaries without getting picked over by the lawyers, courts, and judges, rather than make a lot of money on a few clients that we actually take money away from the people and charities that they believe in. So I'd rather do it the slow and steady way than the big way. All right, so let's jump into our presentation today. We're going to talk about 5 important documents that everybody above 18 years old should have. And looking around the room, I think at least a few of you are over 18. So that is the 5 documents, 3 of which you've probably already heard of. And if you have any sort of a comprehensive existing estate plan, you already have those 3. But they may not be as good as they need to be. They may not be as good as you would want them to be at some point in the future. And that brings me to the big distinction. If there's one nugget I want you to take home, it's this one. There is a distinction between traditional estate planning attorneys and elder law attorneys. Now, we can analogize that to the medical field, where we can all appreciate that all cardiologists are MDs, but not all MDs are cardiologists, right? So when you get a cold, you may not need to go to your cardiologist, but if you have some heart problems and chest pains, you may not want to go to your general MD. So in my world, all elder law attorneys are estate planners, but general estate planners are not elder law attorneys. Why does that make a difference? Well, elder law attorneys do everything that estate planners do, but we have an eye and planning towards folks getting older and maybe not healthier, and maybe needing care in the future. And so our documents are packed full of information and strategies that allow you to potentially get the care that you need in the future without having to draw your assets down to a level that would organically allow government benefits like VA or Medicaid to kick in. So if you're going to be in the same facility, getting the same care with the same food, and option number 1 is you pay $20,000 a month out of your nest egg towards that bill. Or maybe you're in the same place with the same care and the same food paying $2,000. Well, that $18,000 a month gets to stay in your pocket for yourself, maybe a spouse. And then ultimately, when you pass away, that's money that didn't get spent down on your care that can go to your family, friends, and charities. Might make you feel good about being able to pass that down. So we like to give options. So first document we want to talk about is our durable power of attorney. What is it? For anybody who doesn't know, it is a document that lets you appoint someone who you trust, hopefully more than one person, either in a group or in succession, but appoint someone that you trust to step in for you if you ever need assistance with legal or financial decision making. Now, important to note, all the documents we're talking about today, none of them require you to give up your own authority and control. I refer to these documents as the second set of keys to the house, if that makes sense. You still make your own decisions as long as you can, but if the day comes through something like dementia over time, or something very quickly like a stroke or a fall and a head injury, anything that happens in the future that you cannot make your own legal and financial decisions, you have already pre-planned of who you want to step in and make those decisions for you. So I always recommend having at least one backup, if not 2, because Murphy's Law sometimes does terrible things to people. Just got a call 2 weeks ago from a gentleman, and he said, my mom has a power of attorney existing. She's had dementia for about 10 years, and unfortunately, she's at a point where she doesn't recognize anyone. She can't make any of her own decisions. When she drafted her power of attorney, she put 2 agents down, my older brother as the primary, me as the backup. Well, in the last 10 years, a couple of years ago, my brother passed away in a car accident unexpectedly. So now it's me, and I've just been diagnosed with stage 4 brain cancer, and I won't be around for another 60, 90 days. So he says, I need your help in getting another agent to continue to take care of mom. And I said, that's a problem. Because since mom has already lost legal capacity, she can't sign a new power of attorney. And you as the agent can't sign a power of attorney. Your power of attorney agent can't sign a new power of attorney. So unfortunately, we're now going to need to set up a guardianship for mom. And it's going to cost a minimum $10,000. And it's probably going to be, the judge will appoint some professional guardian stranger who might be awesome or might be a little less than awesome. We don't know. And that's what's going to happen fast forward for mom. So when you think about that, statistically, very unlikely that you're going to be predeceased by 2 of your children. But crazy things happen. So I'm always a big advocate to let's have a primary, a backup, and maybe a backup to the backup. And if you don't know someone who qualifies as a backup to the backup, we have relationships with professional fiduciaries that could stand in that kind of last man or woman standing role just to be the backup to the backup. So just note that and think about your own plan if you have it. Do you have a backup to the backup? I can't tell you how many times husbands and wives bring in their documents. There's 1 agent listed. Guess who it is? The spouse. You guys are getting older together. And so by the time one of you need assistance, the other one may or may not be around or available to assist. And sometimes you don't want to put your kids in that position for several reasons. Sometimes you don't want to burden them, and sometimes they're simply not a good choice to manage your money. But that's why we have professional fiduciaries we can introduce you to. So, generally speaking, if you are to have a power of attorney in your existing estate plan, I would recommend that you go home, dust off the binder, find the tab that says Durable Power of Attorney, and simply count the pages. General estate planners will often give you 5 to 12 pages of document. And for someone who hasn't been to law school and done this for more than a decade, it seems like it's pretty comprehensive because it uses broad language. It says my agent can do anything at the bank and anything with wills and anything with trusts and anything for Medicaid and anything for VA benefits. So when you read it, you're like, this is awesome. It includes everything. Literally, it says right there, everything. But the problem is the devil's in the details. There are certain benefits that we may need to go after in the future that require specific language, sometimes a specific sentence. And if that sentence does not exist in your document, your agent does not have the authority, even if your document has the anything, anything, anything language. So our power of attorney is 32 to 35 pages, not 5 to 12. So what's the difference between a 5-page power of attorney and a 35-page power of attorney? Well, all of the tools and strategies, many of which are Florida-only strategies, so they don't exist anywhere else in the country. If you haven't noticed, we have a lot of old people in Florida that vote. So our elder law lobby in Tallahassee is very powerful in getting legislation passed that's good for our seniors. And they literally, it's the Good Old Boy Network, they go down and they twist arms and they say, either you're going to vote for this or not vote for that because it's good for our seniors. Or we have this little magazine you might have heard of called AARP. And if you don't do what we're telling you to do, which is good for our seniors in Florida, come next election cycle, we're going to run a big 2-page spread on how you hate old people and you're making it difficult for hardworking Florida seniors to get their benefits, and then good luck getting reelected. So that's how we get things done. And for the last 40 or so years, Florida has actually been the best state in the country if you get old and need care from an asset protection standpoint. Other states, they take everything. Your house, your car, your money in the bank, your investments, your retirement. They even become the beneficiary on your life insurance by operation of law to get paid back after you pass away. Florida is very different. So we have many rules that are favorable to seniors just to begin with. And then for anything that our favorable rules don't cover, we have strategies that let us go in and shelter that money. So in my career, I have done well over 7,000 Medicaid asset protection cases for people that find themselves needing the $20,000 a month nursing home. We've never had a denial in the history of the firm. And I have done cases for families that had $10,000 in assets. My largest single case, $10.7 million in cash investments and retirement, $1.6 million house. Now, they were my clients before husband at age 73 had a massive stroke and ended up in a $17,000 a month nursing home. But wife came in to see me and she said, I remember when we came in, you said if something catastrophic ever happened, call you, and I'm here. So within 30 days, I had moved everything around. So husband was getting $15,000 of his $17,000 nursing home paid by Medicaid. Wife still sitting on $10.7 million in cash investments in retirement and living in the $1.6 million house. Zero spend down. Zero 5-year look-back period problems. That is the power of our documents. So, since we don't have a crystal ball, and we don't know in the future if we will or will not need care of some sort, it's always best to have these documents in place, because once someone loses capacity, like I mentioned earlier, I can't let you sign a better quality document. So, if you have no documents, or you have documents that you've run out of agents, or they are done by a general estate planner and not an elder law asset protection attorney, or if they're from out of state. Anybody here from out of state? All right. A lot of folks, you guys are not all natives. One person raised their hand. There's like 50 people in this room. You are all not native. Somebody's either not listening or lying. But anyway, I happen to be third generation Florida native, but you guys not so much. I see at least a few northerners in the room. I can tell who you are because your eyes are a little further apart. But just kidding. So a lot of people have their documents done in other states and they bring them to Florida. And they don't think, hey, when I get to Florida, I might want to have these reviewed. So there's good news, bad news here. The good news is every state has reciprocity with every other state. So your Michigan power of attorney is good here in Florida. But it's not going to have Florida-specific language. And since many of the strategies that I rely on to keep you from going broke in the nursing home are Florida-only strategies that need to be specifically outlined in your document, we got ourselves a little bit of a problem, because it's good, but it's only good for the value and the content that's in it. So if you came here from out of state, even if you had a great set of elder law documents from your state and their 30-page power of attorney, it's going to be geared for that state. And if you're planning on staying here for the long haul, there's a chance if you need care, you might need it here in Florida, and your Michigan language isn't really going to carry the day. So there are some documents that you do want to, in a perfect world, have redrafted by a qualified Florida elder law attorney, even if you paid good money to have them done in another state. So that's our power of attorney. The statute changed October of 2011. So even if yours is a Florida document, if it was older than 2011, it's served its purpose. It probably needs a refresh. And so it's a good idea to refresh it. It doesn't go stale, but not legally at least, but technically it is a little stale. So if it's older than October of 2011, needs to be redone. From out of state, should be redone. If it is less than 30 pages in length, should be redone. So that is my 2 cents on durable power of attorney. Again, many things are specific sentences that need to be in there. And if they're not in there, we typically have to go to a guardianship court and spend $10,000 plus just to get in front of the judge to have the judge add the sentence that we didn't have. And then when it comes to asset protection, judges get a little squirrely about giving permission for Florida seniors to shelter their money, whether they have thousands or millions, and push off the cost of their care to the taxpayers because the optics aren't great. But if we have the right language in our documents, we don't have to ask permission. We have authority. And so I don't need a judge to tell me it's okay. I am fully within my legal rights as a lawyer to execute those strategies, shelter your money, and yes, push the money off to the taxpayers. All of us have paid a lot of taxes during our lives, and so if we get a little back towards the end of our life, I don't know anybody who's upset about that. What we do is very similar to a good CPA. We all know that some of the wealthiest families in this country probably pay the least amount in taxes because they have really good tax professionals that use the tax code to their favor. Well, we use the Medicaid code to our favor. It's the same thing. One is taxes and one is paying for long-term care, but it's both saving money that is legally able to be saved. So that's our durable power of attorney. That's number one. Second document is the sister document, and it's called the healthcare surrogate in Florida, in other states known as a medical proxy or a medical power of attorney. Now, same concept. Pick who you like to make your medical decisions. And it may be someone different than your financial. So you may have someone in your life who's a banker, a CPA, business owner, or just someone generally good with numbers and organized and logical. That may be the perfect person to be your primary agent on your power of attorney. They may not be the first person at 3 o'clock in the morning to beat your ambulance to the hospital and be there as the nurturer. And on the flip side, you may have someone in your wheelhouse that's a doctor, a nurse, a social worker, or just the nurturer who may not be the best with your checkbook. And so you get to pick the right person that has the right skill set for the right job. That being said, well into the 90% of my clients pick the same people for all the jobs, but that's okay. If you have an all-around, team player that does everything well, totally fine, but know that you do have the option to change things around. So the healthcare surrogate is for healthcare decisions and HIPAA release. Many people don't appreciate that there is no exemption or exception in the HIPAA law for spouses or for adult-children relationships. So we want to make sure that your agents not only can make decisions medically on your behalf, but receive the information they need to make an educated decision. HIPAA's been around since 1996. And believe it or not, I review lots of estate plans where I'm looking at their healthcare agent form and it doesn't have a HIPAA release. So the doctor can take instructions from this person, but not tell them what's wrong with you. Seems a little silly. So you want to make sure that your document has that. Now, October of 2015, that is when the Florida healthcare surrogate statute changed last. It changed in a really good way, which I'll explain to you in a moment, but I don't think they went far enough. So prior to October 1st of 2015, all healthcare surrogates in Florida said that if one or two doctors deem that I have lost capacity permanently to make my own medical decisions, then my spouse, my son, my daughter, my friend can step in and make that decision. And on first impression, many people go, well, what's wrong with that? That's when I need them. And I said, no, that's not when you need them. Depending on how you lost capacity, you might have needed that person years before we got to that day. I'm sure everyone here knows someone in their life that has had a dementia-related illness and will appreciate dementia is not a light switch. I've consulted with thousands of families that are dealing with a cognitive disorder like dementia, and I've never had a wife bring her husband into my office and say, well, yesterday Charlie was fine. Today he woke up, doesn't know who he is, doesn't know where he is, and doesn't know any family members. Like, Charlie probably had a stroke. That wasn't dementia. So, since Charlie's been having good days and bad days for a number of months or probably years, the old style healthcare surrogate that makes the agent wait until the doctor says Charlie has completely checked out mentally and is never coming back, that agent has been handcuffed to not help make those decisions through that dementia journey. If you're going to take the time and spend the money to appoint someone that you trust to step in and help you in that journey, why are we going to handcuff them until, you get to the bottom of the barrel and you crash and burn? So stories are powerful, so I sprinkle a few of these through my presentation. So let's just say we have a divorced male, and he lives here in Florida, and he has a son who lives out in Arizona. And the son talks to dad every couple of days, and he's noticed over the last month or so that dad's starting to slip a little bit, and dad's asking the same question 2 or 3 times in the same phone call. So he doesn't want to alarm dad, and he knows that dad has an upcoming appointment with his neurologist. So he's like, I'll just, a couple weeks, I'll wait and see what the neurologist says. So dad comes home from the neurologist appointment, and the son calls dad and says, Dad, how'd the doctor's appointment go? Went great. What'd the doctor say? Anyone? What'd the doctor say? Doctor said, I have the best memory of anybody in his 40-year career. And he said, I've actually gotten better since last time I talked to him. So the son knows dad's playing hide the ball, which, everybody laughs, and it is kind of funny because I'm that guy. But sometimes when people get dementia, they do play hide the ball. They're embarrassed. They don't want to admit it. They're in denial, and they don't want other people to know about it. even their own family and friends. So, not uncommon. This story happens all the time, which is how it made it into my routine here. So, son calls doctor. Says, Doc, I know you just talked to Dad today, and he was in there, and I know he's lying to me. Can you tell me what happened? Well, under the old style language, sorry, sonny boy, Dad hasn't fully lost capacity yet. I can't tell you where he is on that journey. So once that happens, I'll be happy to share everything with you. But until then, ask your dad. Well, that's not our best result. Now, the new language under the post-October 1st, 2015 statute revision gives an option for the attorney drafting to make it active immediately versus waiting the traditional route until full incapacity. So, I don't know about you, but I would want that person to take the journey with me. And if it was my son, I'd want him to know I was lying to him, even if I didn't want him to know I was lying to him, because I want his assistance. So, that's why we obviously use the new language. Here's the problem. About 90% of general estate planning attorneys, when this law changed, they don't do what we do. They don't get the call from the son going, what the heck's going on? Dad's doctor won't talk to me. I want to sue him. Well, we can't sue him unless we can sue him. And you got to have the right language for us to sue him. So they just said, well, it ain't broke, don't fix it. Let's just keep our same forms we've been using for 30 years. So even someone who just went down the road to the best Sarasota general estate planning firm and got a new healthcare surrogate, you got about a 90+% chance you still have the old language. It's not malpractice. It's not wrong. It's just not for the purpose that we may need it for in the future. So the short on that is if you have a document from out of state, it's certainly not going to have the new Florida language in it. Needs to be redone. If it is from Florida, previous to October 1st of 2015, not going to have the new language, needs to be redone. And if it was done after October 2015, you actually got to read it. The litmus test is if the same attorney that did your healthcare surrogate is the one that did your power of attorney and it's less than 30 pages, you probably don't have the new language. So good idea to at least have it reviewed, if not amended, because we want the better language. That's document number 2. Document number 3 that you've probably heard of and you probably have in your toolbox is the living will. People get living will, last will and testament, and revocable living trust all confused because the names are confusing. And I have lots of people in my seminars that say, I have a living will and when I die, everything goes equally to my kids. And I go, no, wrong document. The living will, for lack of a better term, is the pull my plug, don't pull my plug document. Anybody here remember Terry Schiavo? Heard that name? Okay. Anybody know how old Terry Schiavo was when she found herself, unfortunately, in a persistent vegetative state? 27. Now, you think back when you were 27, you probably weren't thinking, boy, one day I may lose capacity and be laying in a bed hooking up to machines, and this is what I would want or not want. So it's never too early, although statistically, the older we get, the more likely we may find ourselves in that situation. So what does it do? It specifically says, if I have lost capacity to make my own decisions, I have an end stage or terminal condition, and the only way to keep me alive is keep me plugged into one of these machines, typically feeding tube ventilator, pull my plug or don't pull my plug. And the doctors say I have no chance of getting better. So a couple notes on this document. We should all have it. I've never met someone in my entire career that came in, and when this subject came up, they didn't know exactly what they want. Most people would say, if I don't know what's going on and it's not a good existence and I don't even know who's coming to visit me, like, no thank you. But there are some people that say, hey, my luck, they're going to find the cure the day after they pull my plug, so leave me plugged in. Don't laugh. My father was one of those people. I'm like, Dad, seriously? He's like, no, seriously, they're going to find my cure. I'm like, okay, whatever, Dad. So Dad got what he wanted. And so different strokes for different folks. I'm not here to judge. I'm here to implement what you want. So if Terry Schiavo would have had that 3-page living will, none of us would have ever known her name unless you knew the family, because never would have made the media. Because the doctors knew what she wanted, the family knew what she wanted, and if there was a disagreement, a judge would enforce what she wanted. That's about a 15-minute hearing. That's not 10 years in court and on the news every night. So that is important. Another thing is, and I won't ask for hands because it's personal, but if any of you have ever had the occasion of having to authorize pulling the plug on a loved one, it's not a fun day. Even if you knew you were doing what that person honestly wanted, you carry that around with you, and it's something that I think as a gift you can leave your family is don't pin it on someone who loves you to make the decision. Dad wanted this, he gave the form to his doctor, and now it's time we're pulling the plug. Yes, we're going to grieve and all of those emotions, but I don't have to carry around the, like, I'm the one that told him to pull the plug because none of my siblings would do it. So pick what you want, get it in place, and it eliminates stress and drama on everybody. Now, kind of little sidecar to that document, and that is the do not resuscitate. Get this one all the time. People bring in their estate plan, because by the way, we review your documents at no charge if you have documents and you ever wanted a consultation. So we take a look at what you have and we give you an honest opinion. It's great, leave it alone. It's in the middle, you could maybe upgrade a few things, or it's terrible and you should probably do all of them. So people bring their documents in to review, and I dust off their binder and I go to the healthcare tab, and on this side of the page I have their living will, and on this side of the page I have their DNR. And I go, guys, we don't want both at the same time because we're going to confuse our first responders. Let me tell you a story. Anybody watch The Golden Girls? Yes. Sophia, picture it. All right, here we go. So picture it. You leave here today and you have your annual appointment with your cardiologist. You get there and you're saying hello and you have a heart attack, which, hey, if you're going to have a heart attack right in front of your cardiologist, best place to do it. So here's how that works. If you have a DNR in place, it basically tells your doctors and your first responders, if my heart or lungs stop, you stop. Don't help me even if you can. So, with a DNR in place, your cardiologist understands that you're having a mild heart attack, and she has the skills and the training. She even has the paddles right on the wall, and she has the ability to kickstart your heart and bring you back to good as new. She's going to look at you and say, nice knowing you, Mr. Smith. And she's going to let you die because that's what that document says. On the flip side, you don't have a DNR, but you have a living will. Now your doctor is going to go, awesome, I get to save a life today, and I get to show everybody how smart I am. And she's going to give you the CPR, and she's going to zap you with the paddles, and she's going to go home and tell everybody she saved an old person's life today. Not that you're old, but if you were. So that's the difference between the DNR and the living will. Drastically different result on a simple heart attack. So I always phrase it this way, and I always ask the question to my clients. If that were you today, and you had the heart attack in front of your cardiologist, and she brought you back, and you spend a few weeks in the hospital relatively uncomfortable, but you made a full recovery, and 2 weeks after that, you're at your cardiologist's office for a checkup, do you give your cardiologist a big hug and say, you are awesome, thank you for saving my life? Or do you look at her and say, I wish you'd have let me go? If you're the, I wish you would have let me go person, then the DNR was your friend. If you are the, thank you for saving my life, because I live in an awesome community and I love my great-grandkids and they all come to see me all the time and I have friends, then you still got some life in you that you want to enjoy. You want the living will, but you don't want both at the same time. So that's that. Now, a couple of DNR trivia questions. What color paper in the state of Florida does your DNR need to be written on or printed on for it to be effective? Yellow. Yellow. You guys are good. So, I heard canary yellow. This leads me to my, you took part of my joke away, but all right, let's go. So, it's not in the statute. It's actually in the Florida Administrative Code that says for your DNR to be effective, it needs to be on, quote, some shade of yellow. So you have a little artistic freedom on this one. If you like Easter and you like the pastel yellow, you go with that one. If you are sad that the 80s are gone and you like neon yellow, you get to pick that one. This lady's got a yellow shirt on. I know what color yellow you're picking. So just make sure it's on some shade of yellow, because believe it or not, if it's on a white copy paper, they're going to bring you back, even if that's not what you wanted. It's got to be on yellow. And the legislative history on that and the rationale is that yellow papers stick out in a sea of white papers, and so it's easy to find a yellow paper, even if it's only canary yellow. So that is the yellow. Now, second piece is, where should you put your DNR? Because it's only as good as the first responder knowing you have it. So where in your house are first responders trained to look for the DNR when they come to revive you? The fridge. All right. So here's don't shoot the messenger, but here's how I would handle it if I were you. We all have pictures of our family members on the fridge. Find your least attractive family member and take your DNR and you magnet it right over that person. Might be one of your grandkids or great-grandkids, because sometimes they're questionable. So find the least attractive one. You're not going to miss anything. Just post it right there. All right, just kidding. I'm sure they're all beautiful, wonderful people. So that's one option. Where's the second place? By the front door. So when first responders come in, they're going to head check if they see a thumbtack on the wall with a big yellow paper on it. They're probably going to take a pause and make sure, see if that's you, and then they'll know whether to help you or maybe just call the coroner to come get you. So freezer is one that I've been hearing more often, and I actually heard it from a first responder. And the rationale, I don't know if I buy it, but maybe, is that if you get dementia, sometimes people with dementia start hoarding stuff or throwing things away. You're probably not going to search the freezer to find a legal document to throw it away. Again, I don't know, but we'll throw that in there as an honorable mention. But where they won't go is in your file cabinet, in your home office, and thumb through while you're not breathing to go, healthcare, where is healthcare? All right, let me find the healthcare and let me look for the... No, they're going to get to work. So this document isn't perfect, because if the first responder doesn't know you have it, they're going to do their job, which is bring you back, even if that's not what you wanted. So let's make it as easy for them to know that you have one. If you live in a senior community, most require it, but even if they don't, I would volunteer to give one of those yellow copies to the front desk. So if, God forbid, they ever have to call the ambulance because you're having a moment, they can hand it to the first responders on the way in, and Mrs. Jones on 212, and if she's not breathing, use that. So that lets the first responders know as they're coming into a community, a senior community, independent living, assisted memory care. One person said, what if I just tattoo DNR on my chest? And that way when they open me up to give me the chest compressions, they'll know. And I said, but it's not on yellow paper, so it's not going to work. But I do like the way you think. Other people have also asked me about the medic alert bracelets. I don't see them too many these days, but back in the 70s and 80s, they were pretty popular. Again, not on yellow paper, so chances are they're not going to honor that even if you had one. All right, so that's DNR versus living will. Pick a lane, whichever way you go, and then we can always change that lane in the future. There are some times when life gets to be to the point where you are honestly ready to check out, and you may have chronic illnesses that make every day relatively uncomfortable. And you would prefer not to be brought back. That's okay. That's when we take the living will and we circle file it, and then we give you the yellow paper, and now you've changed lanes, shifted gears, but you are in control. Don't have both papers at the same time. All right, so those are the big three, and those are the ones that most people have heard of. Most people have... Yes, ma'am?
What if you are in public?
Yeah, so a little tricky. The DNR officially has the lower, I want to say left corner, where you can cut out, and it's about the size of a credit card, and it is still on the yellow paper, and you can put that in your purse or wallet. My suspicion is that first responders, again, probably aren't going to be digging in your back pocket or looking through your purse to try to find the yellow paper. So not as good as it could be. It's not fail-safe, but it's probably the best we can do is to have the personal ID card on that. I mean, you could always staple the yellow paper to your chest, but that would be painful. There's some weird people out there. Whatever floats your boat. Good question, though. So it's only as good as people know it's there.
Does the hospital need a different form from one of the standard forms?
Nope, the hospital will use the standard form. And now be careful with that, because depending on what hospital system you go to and their electronic medical records, if you're a frequent flyer at the same hospital, they may actually have that in your electronic medical records that you are a DNR. But if you go to, one Baycare group, one hospital, and then you go to Florida Hospital and you go to Advent, then they don't share the electronic medical records between different enterprises. And so you would need to give them a fresh one, or at least show them yours. And you may get wheeled in unresponsive, in which case then it gets a little sketchy. Your family's got to bring it in. So, but it's only as good as even the hospital system knowing what you want. Good question. Yes, sir.
If you're traveling by car, let's say from here to New England, and something happens, if you have a copy of that, with a partner.
Yeah.
But have a copy with you, will they honor it in another state?
Every state has reciprocity. They may not know the yellow rule, but it's pretty self-explanatory what that is. Some people put it in the glove box, but again, terrible car accident and they're pulling you out and doing CPR, they're not going to be checking your glove box to see if there's a DNR in there. So, but yes, I would have it with you on travels. Yes, sir.
For a person that has a living will, and had full capacity when it was created, but reaches the point that a DNR is appropriate, but no longer has the capacity, how should the person with the living will proceed?
So, a little tricky, and it's a technical answer, and then even then, sometimes hospitals just do their own thing. I've heard countless stories of there was a DNR and they brought him back anyway. And so there's a lot of things that go on to that. But in the document, the living will does have an option that basically says, if I in the future do a DNR, my agent, or I'm sorry, not in living will, in the healthcare surrogate. In the healthcare surrogate, it says, if I have a DNR, my healthcare surrogate shall honor it. If you want the flexibility, then you may, for your healthcare agent to be able to switch you when the time is right, even though you're not able to communicate that or understand it, then we simply take that language out. And so you can give the healthcare agent the authority to pull the plug, don't pull the plug. And so some of my clients that have that exact concern, they don't do the living will or the DNR. They simply rely on their healthcare agent to make that decision. So there's a little flexibility there. Yes, sir.
Do you mind repeating the question for us back here?
Absolutely.
Summarize.
I don't remember the last three, but moving forward, I will repeat them for you. I seriously don't remember them. Anyway, I have a squirrel for a brain. Okay, any other questions before we move on to document number 4? So again, the last three have been the power of attorney, the healthcare surrogate, and the living will. If you have any sort of comprehensive plan, you have all three. If you don't, your lawyer was terrible. And if they're not, 30 pages on the POA, have the new language in the healthcare surrogate, and have the most updated language on the living will, probably a good idea to have them refreshed while we still have our mind and we still have the possibility to do it. Because you can't buy the homeowner's insurance, when the hurricane is knocking at your door. They don't sell it to you then. You can't buy it when your roof is on fire, and you can't get the new elder law asset protection documents after you've had the stroke that puts you in the nursing home and takes away your capacity. The next two documents are documents that we do and most elder law attorneys do that most general estate planners don't. The first one is known as a pre-need guardian. And that is, if you need a legal guardianship in the state of Florida, the statute lets you pick your spouse, your children, your friends, your family to step into that role and be your court-appointed guardian. If you fail to do that, there is a decent chance, maybe more than a decent chance, that the guardianship judge just takes the lazy route, pulls the next name off the rotation for professional guardians, and appoints someone to you. You might get a great one. Any professional guardians in the room? Okay, good. I stepped in this one day and it was very uncomfortable. Anyway, so I preface this by saying not all professional guardians are bad people, but there's always a few bad apples in every profession. Lord knows lawyers are not immune to that one. So just about 4 years ago maybe, the president of the Pinellas County, so just a county or two north of here, the Pinellas County Professional Guardians Association was arrested and hauled off to federal prison for stealing over $2 million from her incapacitated wards. Now again, that's the one bad apple. There are millions of great guardians. But it's not too far away and not too long ago, so I raise it. My thought is, I want to have the most control and take away the least amount of government oversight and decision-making for me. And that's not a political statement, that's factual. The government's not really efficient at anything, no matter who's in charge. So I want to be in control and not some bureaucrat somewhere that creates a system for people that didn't take the time to take control. So you get to pick your guardian, and that comes up in a couple of scenarios. So a lot of people will are thinking or will ask the question, well, why do I need a guardianship if I already have power of attorney and healthcare surrogate? And it's a very valid question, because in Florida, the guardianship law is clear that a guardian is the last resort for someone who otherwise doesn't have someone to make the legal and medical decisions. So on first impression, the guardianship should 99% of the time be unnecessary when you got a really good power of attorney and healthcare surrogate and they're doing their job. But getting back to how different people handle things like dementia or just getting old and cranky, a lot of times people will get paranoid and they'll think that their family member who's trying to give them their daily medication is trying to poison them, or they're trying to steal all their money, and so they're constantly calling 911 and the cops are showing up and it's a whole thing. So there are times where we need to get a judge involved. My fun story about that is several years ago, it's probably been a decade ago, I had a World War II veteran in his 90s, and he used to go to the gym every day. He wasn't in great shape, so I'm pretty sure he wasn't going to the gym to get healthy. I think they had the cardio equipment right outside, like the aerobic studio. So I think he just went to look at the girls. But anyway, not my business why he went to the gym, but he went there every single day. So his daughter, who was his power of attorney agent, used to come and have Sunday lunch with Dad. And so she starts coming and she starts noticing every Sunday there's a new dent or ding or scratch, or the wheels are all rashed up. And so she's, Dad, what happened to your car this week? Oh, these Florida drivers, they're terrible. And they keep pulling out in front of me. That mailbox pulled out in front of me last week. So daughter starts to have a little bit of concerns that Dad maybe shouldn't be driving. So she eventually calls me and says, what do I do? Now, I'm going to tell you something. Please don't do this to your neighbors, unless you don't like them. The DMV here in Florida has a little anonymous turn-in form. So you can report someone for being a terrible old driver, and they don't even know who you are. Don't do this to your neighbors. So anyway, if you turn in this little anonymous form to the DMV, it triggers a medical request form. So the daughter sent in the anonymous form, and the DMV sent Dad, and he was in his 90s, sent Dad a form that says you have 30 days to get back to get to your doctor and have them complete this, diagnosis that you're able to drive. And if you don't, we're going to pull your driver's license. So of course, Dad marches right down to his doctor and immediately miserably fails the driving test and the medical thing. So DMV pulls his license. What does Dad do? Keeps driving to the gym. So then it comes time to renew the automobile insurance. And believe it or not, there's no licensed drivers in the house. So they cancel his automobile insurance. What does Dad do the next day? Drives to the gym. So daughter finally has to have the very difficult conversation with her World War II drill sergeant father, who wasn't taking orders from anybody, even at 98. And she says, Dad, I'm going to have to take your keys and I'm going to have to sell your car. So what does he tell her? You touch my keys, I'm going to call the police and tell them you stole my car, and I'm going to have you arrested. So that's one of those moments where we have to take a time out and say, Judge, we do have power of attorney and healthcare surrogate, but Mr. Smith over here is a danger to everybody on the sidewalk. And so we need judicial authority to do what needs to be done without the daughter getting arrested for stealing his car. So few and far between, but they're important. And my job isn't to run the numbers on what you might or might not need statistically. It's to give you the kitchen sink, because again, when we get there, we can't fix it. So pre-need guardian, very important. And not going to be part of 99% of general estate planners' document sets. That brings us to our fifth document, which is our final arrangements. And many people are like, but wait a minute, why do I need a legal document for final arrangements? When my mom died, I just went to the funeral home and paid for the funeral and everything went well. And that's true. Like, there's no legal requirement to get a funeral or a cremation to have a legal document. But there's a couple things I want to mention. One is that sometimes different people grieve differently when someone passes away. And so even though they may have played well in the sandbox their whole lives, siblings sometimes can go at it over the darndest things. I've actually had reports of like fist fights in the funeral home over the color of Dad's casket hardware. It wasn't about that. It was about they were just grieving and they didn't have their filter on that day. And so they decided to take out their years-long frustration on their sibling by arguing over the casket hardware color. So you get what you want and you don't get what you don't want. So that's important. And secondly, you put a order of operations, just like a power of attorney, on who is in charge of any decisions that need to be made at the time. Now, I highly, 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 and I don't make any money on this, but I still highly recommend that you pre-plan and prepay for your final arrangements. We have a funeral home girl, we have a pre-plan agent here in the room? Someone, anyone? All right. Oftentimes we do. So what I recommend is you pre-plan it, prepay it. I think, again, one of the best gifts you can leave your family member is, hey guys, when the dime comes, here's a phone number. Pick the date and show up. Those are your only jobs. If not, and again, if any of you have had the not so fun day of having to go at need, usually within a day or two of losing a loved one, and you're sitting there picking the casket hardware even if no one's arguing with you, you don't want to be there that day. And your family doesn't want to be there that day either. So it's your opportunity to say, hey guys, it's all taken care of. And then depending financially, funerals ain't cheap. Not uncommon, $15,000, $20,000 if you do a traditional funeral. Sometimes the children, well, they don't have their inheritance yet because your money's all still locked up. You just died yesterday. The funeral home isn't going to take an IOU on that. And now all the kids are trying to figure out who's going to pay for it and then worry about trying to get paid back, when the dust settles, which doesn't always happen. So that is a scenario where I think you should do that. And then picking the order of operations of if there is a disagreement, who is legally entitled to make the decision. Here's where this comes up. Blended families. I get phone calls at least a couple times a month. It's usually a woman crying. What do I do? How can you help me? My husband of 30 years died, 3 days ago, second marriage. I'm trying to make the funeral arrangements and his daughter has called me now and said she's blood and I'm not and she's in charge and I was a terrible stepmom and I'm not invited to the funeral. These things happen.
Thank you.
Not my first rodeo. I've seen a few. So my thought is if you want your premarital son or daughter to make your funeral arrangements, we'll put it down on the form and your wife might not be happy about it, but it is what it is. Most often you want your spouse to do it. And if your kids don't like it, it is what it is. So get the order of operations down in case someone decides to not play well in the sandbox because they're grieving your loss. So those are our big five. I think everybody should have them. Technically, when you turn 18, I tell my families this, when your children or grandchildren turn 18, you are no longer legal mama bear and papa bear. You are now biological mama bear, papa bear. And kids go off to college and do the darndest things, and it usually starts with hold my beer and watch this. Then they end up in the emergency room, and the parents come rushing in only to be told, I'm sorry, we can't tell you what's going on with little Johnny, and you're not allowed to make any decisions because he's 18. So maybe a little gift, kind of weird, but a gift for your children, grandchildren who are turning 18 and going off to college and drinking a lot of beer. Get them these documents in place because that allows someone to continue to be legal mama bear and papa bear. So those are the big five. Everybody should have them. Young, old, rich, poor. These are not save your millions. If you don't have millions, that's okay. A lot of these are personal dignity choices that you should have in place. Because we're a never hide the ball firm and I'm fully transparent, everybody always asks me, well, what's your price? So I just give it to you. For all five documents that we just talked about, my fee is $1,500. So when you break it down, it's $300 a document. They'll last you for the rest of your life. Yes, sir, it is cheap. I'm glad you think that way. Affordable. Would you like a job as a marketer for me? I would like for you to go around town and tell everybody how cheap I am. So the theory is, listen, profit is not a dirty word, and I am not a charity. So we are in business to make money, but I would rather make it based on the relationships, and I'd rather cast a broad net and protect 10 times as many people at 1,500 than as 15,000, and I can help more people. My goal, and I don't take a case unless I can leave a person in a better place than I found them. And sometimes somebody calls me for benefits and I literally tell them, like I just had one the other day. They wanted Medicaid for mom who's been recently diagnosed with dementia. So we start looking at all the assets, and mom's got like a $1.7 million IRA, which is spitting out like $70,000 a year in distributions. And when I did the math, she's making like 20 grand a month after her long-term care insurance. And I said, listen, I'd love to sell you a $14,000 Medicaid plan, but quite honestly, Medicaid's never going to pay a penny because even if mom ends up in the $20,000 a month nursing home, Medicaid only pays the shortfall. Your mom's not going to have a shortfall. So I appreciate you want to write me a check, but I'm not going to take it, because if I did, and later somebody was like, hey, that lawyer ripped you off, now I look like a, never mind. And lawyers are very good at looking like a, never mind. So I try not to do that as often as possible. And honestly, those folks that I tell, like, I thank you, but I don't want your money, they will go out and refer everybody in the world to me because I didn't take their money. And so they become my little marketers. So we don't kill people on prices. It's an honest price for an honest document. You can get non-elder law attorneys to do that set cheaper. Just know you're sacrificing all the bells and whistles we just talked about. So unless you feel very comfortable, you're never going to get old and you're never going to slip on that banana peel and end up in the nursing home, you probably want to buy the insurance, which gives you all of the tools we need in our toolbox for future asset protection. Question?
On the number 4, you gave one example of a pre-need guardian about a car. Who makes that? What are other?
So I've had other times where seniors get dementia, they get paranoid, and they are convinced that their power of attorney agent is financially exploiting them. They're stealing all my money. They're not stealing your money. Or they're stealing my stuff because they get to be hiders, and they take their gold watch and they hide it under the sofa, and then so no one steals it. And then they forget where they put it, and then they blame their son or daughter for stealing it. And they're calling the cops. The cops keep showing up. So at some point, it's a good idea that we have a court order that tells the cops, or they put it on file down at the 911 center, that, hey, this person is under a legal guardianship. They do not have capacity to, and so don't send the cops. So those are some examples. Yes, sir.
Being Italian, I like you, number 1. And if I want to contact you, do I have to go to Tampa, or will we meet here or what?
Great question. So once our Lakewood Ranch office opens, if it ever does, you're welcome to just drive down the street and see us there. But in the meantime, you never need to drive to Tampa. Until our office is open, we will come to you, and there's no charge. Now, obviously, if you're comfortable on the phone or Zoom call, it's much more efficient for us to get that done. If you want someone to come into your community, it often will not be me. It'll be one of my associates. They're all smarter than me anyway, so it's fine.
I want you.
I'm the dumbest guy in the whole place. Just ask anyone who works for me. Jennifer, that was not you. So that's, yes. But yes, we will always do it in person if you want it. There's never a charge for it, including if we have to drive down here to meet you. There's no charge. And if you have documents, we review them. If you don't have documents, we get them in place. And so that's the 5 documents. Now, how am I doing on timing, and where do we need to be?
Well,
I don't want to keep anybody for dinner.
and I think that leads into a very, very good question about the follow-up that Jennifer and I have been talking about. I don't know if you've established some dates as yet for people to come back here.
All right, so let me tell you the compliment of if you think I'm relatively entertaining and I might know a thing or two, then welcome to come back for more stuff. We do a wills and trusts, where we talk about the difference between wills and trusts, why you may want one or the other. Quick highlight, wills and trusts do the exact same thing. They let you pick who's in charge of your stuff when you pass away and who gets your stuff when you pass away. But they do it in different ways. They have different costs to set up, but they also have different advantages when you pass away. So one size does not fit all. There's some attorneys, everybody needs a trust. Well, because they make more money on selling trusts, but it's not always necessary. So we'll do wills and trusts. We do VA benefits for veterans and widows, which in some cases can actually pay for independent living. So even if you live here and you're independent or assisted or memory care, in certain circumstances, with the right applicant, we can get up to $2,700 a month direct deposit, tax-free for the rest of your life, to help offset the cost of care, and that can go a long way. An extra $32,000, $34,000 a year tax-free, so that you're not draining your assets as much as you currently are, and you still get to stay in the same place with all the same goodies, but costs you less money every month, which means your money will last you longer. Yes, ma'am.
With VA benefits being like a national benefit, so I have scenario client, we worked for a year trying to get VA benefits, he passed away, then they closed the case and her family moved her near them out of the...
Yeah, I'm licensed to do VA anywhere in the country because that's a national accreditation. Right. Whereas the estate planning and the Medicaid stuff, I stick to Florida because that's where I'm licensed. But
And for the VA piece of that, once the family, because she was just exhausted, is there a way to open that back up?
It's a separate application for a surviving spouse versus the veteran. Even if the veteran died after getting benefits, it doesn't automatically transfer. Now, some do. Service-connected disability can turn into what's called a DIC, or a disability indemnity compensation claim, but the aid and attendance. So real quick, anybody here heard of aid and attendance? That's a veteran or widow veteran? Literally just one, two. So most veterans don't know about it. Most widows don't know about it, but it's direct deposit, tax-free cash. So if you are a veteran or widow, you want to know about it. And if you know other people, invite them to come do that. And then we do Medicaid asset protection. Again, typically just for that catastrophic nursing home event, but it can save you $240,000 a year on your nursing home. Might be something you want to learn about. Yes, sir.
VA benefits for this means tested?
They are. Both Medicaid and VA benefits are means tested. We have done probably close to 6,000 on the VA side, never had a denial, and over 7,000 on Medicaid side, never had a denial, including some families that have well over $1 million in assets. So they are means tested, but there are strategies that are legal and legitimate to, on paper, drop you below the means test. Yes?
Getting all of these documents in order here in Florida, what if somewhere down the road your kids say, we want you up?
Sure.
Do I have to get new documents when I go up north?
The answer, so the question is, see, I can be taught. The question is, what if I get my documents done with you here in Florida and then I move somewhere to be next to my kids? So we start off with the general proposition that every state has reciprocity. So they will be good in your other state, but if your other state has specific language that is to their state, probably not a terrible idea to have them reviewed and done. Now, some other states most other states are not as friendly as Florida. So if you haven't planned under their state's rules 5 years before you need care, whether you have my documents or anyone else's, it won't matter because you don't have 5 good years before you need to go on claim. You're going to be in a spend down mode. But general proposition is when you move, you should always have your legal documents at least reviewed by a competent attorney in the new area. Yes, sir. Miss Ma'am, and then I'll get you.
Two questions. Titling your homestead, I'm from Texas, and there's a way you can title so it passes automatically.
Okay, let me answer that one so I don't forget the first one and I can repeat it. So, titling your homestead, how do we do that? Well, a couple of options. Florida, I think Texas is one of them. 5 states in the country recognize something called a ladybird deed or an enhanced life estate deed. Effectively, what that does is puts a beneficiary on the real estate. It can be used for non-homestead as well, but it puts a beneficiary. So when you pass away, $10, we record your death certificate with the county, and the county automatically changes the name over into the new owner. Now, fun fact, if you are inheriting a property from a parent and they still have a mortgage on it, there is federal legislation from 1982 called the Garn-St. Germain Act that prevents the mortgage company from messing with your kids and forcing them to refinance or get a new interest rate or call the loan due. The federal law requires that they allow your child to assume your mortgage under the current term. So that's kind of fun since interest rates are higher now than they had been historically. So ladybird deeds are an option. But ladybird deeds fall into the same world as general beneficiary designations, which in my opinion are better than nothing, but not perfect. Here's why. You get old, however you define that. It's a moving target. You get old, let's say you're in your 90s and you had your kids in your 20s, so now they're in their 70s. You're 99, you have a 78-year-old son, you have dementia, you did a ladybird deed while you had capacity to put him on the property, and then he has a stroke at 78 and ends up in a nursing home. Well, now he's inheriting your house and maybe your bank account, your investment account, your retirement accounts automatically. So not so good. What if he predeceases you and you don't have the legal capacity to go back and retool things? Now it's rolling back to probate. So the beneficiary designation, whether it's a ladybird deed or a POD, TOD, anything else, it's only as good as everything going according to plan. If your beneficiary dies before you, not so good. It's probably going to go to probate. If your beneficiary becomes disabled or on public benefits before you pass, then they're probably going to lose their benefits that are means tested. If they are in the middle of a divorce, lawsuit, bankruptcy, You don't want to pour gas on that fire. So they may lose half or all of it, depending on how things go. And then if they've developed a drug problem, a mental illness or something where it would be a really bad idea to give them a lump sum, beneficiary designation just writes them a check regardless of their issues they may be facing in life. So that's where the trust comes in. A well-drafted trust has protections for all those things. Where does my stuff go if my beneficiary predeceases me? Boom. What if it's going to a minor? Well, now we have language for minors. What if my son is on Medicaid in his nursing home when I die? Well, his share will automatically turn into a special needs trust and not be countable, not mess up his benefits. Divorce, lawsuit, bankruptcy, we pump the brakes, let the coast clear before we give him his inheritance. And, you know, if he fell off the roof a couple years ago and unfortunately got addicted to prescription opioids and now has a problem, we don't want to hand him cash. My trust can automatically convert to a discretionary trust in that without you ever having to do anything. So it's all about protection and hedging risk. Now, a beneficiary designation on your checking account is 100% free. You go down to Bank of America and say, when I die, give it to my son. Doesn't cost you anything. A trust costs you thousands of dollars. So everybody gets to make the decision. Do I sleep better at night spending the thousands of dollars on a trust, knowing that if any of these crazy things happen to any of my family, it's going to turn out good? Or do I save the thousands of dollars and roll the dice that hope everything does go well, and if it does, I saved a bunch of money? No crystal ball. And that's what we kind of walk with you down the rabbit hole of, or if you're the buy the insurance girl, then you probably want to trust. If you're the kick the can down the road and deal with it when we get there, you probably don't want the trust. No way to tell whether you're right or wrong until the time comes.
So these are testamentary trusts?
Yes. Yeah. Well, they're inter vivos. We set them up during life. A testamentary trust is a trust that comes to life in your last will and testament. Those are terrible because all your assets have to go through probate before it funds your trust. So 6 to 12 months in the court system, attorney's fees, court costs, filing fees, publication fees, bond, paralegal fees, and personal representative fees before your trust gets funded. I don't know about you, I'd rather skip that entire process, including all the fees and costs, and do an inter vivos trust with all the protections, and now nothing has to go through probate before it dumps into the trust. Lots of attorneys draft testamentary trusts. Bless you. No one has ever been able to explain to me why you would do that other than putting money in, padding the bill, so when your client dies, you get to take them through probate and make a bunch of more money on them to fund the trust that you charged them to produce. Just my thought. Yes, ma'am. Oh, we got a second one.
Yeah, my other question is, in Texas, once you do die, then anyone that was related to you, I think by blood, can have access to your medical records. So whereas HIPAA protects you while you're alive, is there a form here in Florida where you can be, your medical stuff can be protected from access hosts?
I am not usually stumped, but I am not aware that Florida has a provision like that.
So does that mean your relatives can come and get access?
That I'm aware of, no. There may be something I'm not aware of. I don't have a lot of people asking for medical records after someone passes away. So I would have to do some research on that one. I don't know what the default in Florida. My understanding is there's not something that automatically gives blood relatives. They can get your death certificate, but not necessarily go and pull all your medical history. But I would have to research that before giving you a definitive answer. You had a question, sir.
I do have two. You mentioned a lot of people do move north after they're near the end of their life to be near their family.
Sometimes.
And that you probably should review all your records when you go back north.
Mm-hmm.
Does the plan that you set up in Florida get nullified for the 5-year look back if you go back to another
No,
state?
when you move to a new state, so if you move to another state, are you nullified or not have to follow the 5-year look back period because you planned in Florida? The answer is no. Every new jurisdiction you move into, you got to play by their rules when you get there.
It's a new 5-year look back then.
Yeah. Now, Florida, we avoid the 5-year look back period we talk about in our Medicaid planning. None of my, I think I probably have 5 clients out of 7,000 that have ever used a 5-year plan to avoid Medicaid clawback and avoid the spend down. Because in Florida, I have strategies that are simply not subject to the 5-year look back period, so I don't have to worry about it. So that's that.
That's a good answer. I had 2 questions.
2 questions.
The other was,
Getting ahead of myself.
What are your findings about passing on your assets to your grandchildren and skipping your children?
That's wonderful.
So, my findings. It all depends. how crazy are your kids and how much do you love your grandkids? So there's a couple of techniques.
And love them a lot.
Done. So there's our answer. So I have lots of clients that say, listen, my kids are doing great. They don't need the money, but the grandkids are just getting started in life and they need college and they want to buy a house and get married. And so a lot of people go straight to the grandkids. We can put contingent minors trust language, and it doesn't have to be age 18. Most of my clients choose like 25 or 30. That's another story. So yes, we can go straight down. We always have to be careful with something called GST, or generation skipping tax. So we want to make sure that we look at the tax angle, depending on how much you're leaving. I mean, if your millions have millions, we want to look at GST. If you're an average Floridian with, sub $1 million going to the grandkids, then not so big of an issue. But it's always something we want to be on the lookout for. So that is skipping your kids and going to your grandkids. You guys are awesome. Yes. And then I'll work my way around.
Different states have different estate taxes. So one would have to be careful moving to a different state.
Yeah.
Because all of a sudden you might have your assets taxed extra. And the same thing with income tax.
So state.
Where does Florida stand on the estate tax side?
It's the best in the country because we have a lot of old rich people that die here. So here's how that works. So Florida, unlike many states, does not have a state-imposed estate tax. If you notice, George Steinbrenner, Mr. New York, buried right up the road in Trinity, Florida. He was a Florida resident, which saved him at least $30 million in New York State estate taxes. So many states that do have a state-imposed estate tax, yes, if you move there, you're going to be subject to it. So that's one of the things, that's why a lot of people move to Florida. But if you decide to move back, just know you might be subject to it. Because Florida does not have a state-imposed estate tax, we use the federal system, which for this year is set at about $13.9899 million per person. If you're married, you double that. So you're pretty much $28 million as a couple before you would be subject to federal estate taxes for this year. Now, fun fact, that provision is ready to sunset December of this year. If the legislature does not act, it will fall back to about $6.34 million per spouse, which still covers the vast majority of Floridians. But if you happen to be at the north of 13 million, but south of 28 million, you could get caught in that.
Is that separate from this tax thing that they're dealing with right now?
It might be part, they usually do something called an omnibus, act that does a bunch of different things. So I'm not sure if the one you're talking about includes it. My suspicion will be based on the current administration and who's in charge in Washington, that they will extend it, if not move it forward. And honestly, it's been bipartisan. So if you go back to pre-2010, the estate tax federally was only exempt at $1 million. And there was a 55% tax on everything above $1 million, including the death benefit of life insurance policy. So if you had a $2 million life insurance policy, even if you were otherwise broke, $550,000 of your life insurance didn't go to your family. It went to Uncle Sam. So in 2010, then President Obama, so we have a Democrat there, raised it from 1 million to 5 million. So we go, okay, the Democrats like it. And then Trump and his first administration went from 5 to 10 million. So you go, hey, the Republicans like it. They both like it. Why? Because they don't want to make mad their old rich constituents that when it comes election cycle, they're asking for donations. Doesn't matter Republican or Democrat, you want your old people to give you money. And so it's a really tough sell to say, hey, in my last term, I cut it from the 13 million down to 1 million and put it back to 55%. So yeah, I just cost your family $7 million when you die. By the way, can I have a campaign donation? So it's kind of political suicide no matter which side of the aisle to drastically lower it. So I think it's going to stay the same. For the last 40 plus years, it has either stayed the same or gone up. I suspect that will continue no matter who's in office. Yes, ma'am.
Once you put all your assets into a trust and you need some of that money, can you pull out some of that money?
Depends. So if you put your assets in a trust and later you need the money, can you pull it out? Depends on the type of the trust. If it is a traditional estate planning revocable trust, 100%, it's your money. You hold the checkbook. You can go gamble it all the way tomorrow if you wanted, and you don't have to ask anybody permission. If it is a traditional irrevocable trust used for Medicaid asset protection for a lot of our northern states where you got to plan 5 years before you need the care. You cannot hold the checkbook and you cannot be a direct beneficiary. So the answer would be no. You can't directly pull the money out, but there's always a round robin way. Your son, who's the trustee, writes your daughter, who the beneficiary, the check, and then she takes you down to the hearing aid place and spends $8,000 on your new hearing aid. So they can't give you the money directly, and you don't hold the checkbook, but there are ways to get it out. In Florida, we're blessed to not have to really use that irrevocable restrictive trust. Between the documents I talked about today and a general revocable trust, I can protect 100% of your home, vehicles, cash in the bank, investments, and retirement if you ever need nursing home, and I don't need to use one of those 5-year trusts. So there is your answer. Sir, you had a question?
We pay you all at once or prepayments? How do you work?
You pay me yesterday. That's how we do it.
How do we pay it?
We do pay it up front because, first of all, it usually for these documents takes us only a few weeks to get it done. And if for some reason you decide after the fact that you're not going to pay us after we've done the work, I can't repo it because nobody else wants your work product because it's got your family on it. So yeah, paid up front and then we deliver the...
For people that are going back and forth between different states, how do you decide which state to have all these documents?
So, this is great. I meant to mention this earlier. We have a lot of snowbirds or people that spend significant time in more than one state. Believe it or not, I recommend having a good quality set of advance directives in each state that you have a contact with, so that if you're in Michigan when you have the stroke on the winter months or summer months, then you got good documents there. And if you have the stroke when you're in Florida, you got good documents here. We can draft it where one doesn't cancel out the other, and you actually have two sets, one for each jurisdiction.
What about your will?
Just go.
How are we doing on timing? Because I want to answer questions, but I don't want to keep everybody too late.
No, that's fine.
All right, just give me the hook when you want me to.
No, go
What
ahead.
about your will then? Is it wherever you spend more time? Or
So wills are good generally around the country. There's a couple of caveats. If the state that you don't have your will in is where you're living when you die, it can cost more to probate the will, which is why I recommend a trust. But yes, every state has reciprocity.
How many elder care attorneys you have in your firm?
So right now we have 4 attorneys. We have 30-something support staff. So
they're all elder care.
yeah, that's all we do, bread and butter.
And where's your office going to be in Newport Ranch?
It's going to be right behind Owen's Fish Camp, right where there's Ruth Chris, Bar Italia, right in there. Beautiful plaza.
And how can I contact you directly? Because I have other questions.
Thought you'd never ask her. All right, so let's do that now. Anybody who wants a consultation to talk about other stuff or have your documents reviewed, we haven't handed them out yet?
No, because they didn't.
Okay. Anybody who wants one, do not leave without seeing Miss Jennifer here, and she will get you one. Here, here's one for you. Huh, look at that. I'm like Vanna.
When are you having the next?
Well, we're going to have 2 dates.
We're going to have 2 dates, and I'll be back. But in the meantime,
We'll do trust.
We're going to
Yes.
do it in the community here, so anybody who wants to have one, free consultation, fill these out, get this back, and then we will work on the dates. Right now, we have the 9th and the 11th for it.
all right. And if anybody doesn't want to wait that long and wants to get in, we can do phone call or Zoom, where we can answer all your questions and get you signed up and do all that sooner.
So what is this form now?
What is
that
his
they
form?
have?
That is a consultation request form. So if you want to have a one-on-one with us, private conversation, where you can tell us all about your crazy family. You don't want to tell me about
What do you need on that now?
name, phone number, and what topics you're interested in talking about.
And they will give it to you before they leave today.
Yeah, give it to us, so give it to Jennifer before you leave, and then someone on Monday from my office will call to schedule. If you want to do phone or Zoom, we can do it very quickly. If you want to wait till next time we're out in the community, it may take a little bit.
So once again, on June 9th, which is a Monday, and June 11th, which is a Wednesday, we're planning on scheduling Alderman Oaks being a place where you can come to and scheduling, they're about hour sessions,
Usually about 45 minutes.
45 minutes.
Yeah.
All right, so,
It's free.
Yes, ma'am.
okay, so there's really a couple of options. One, directly, based on the Jennifer's little sheets. 2 would be, let us know on those sheets or on the info sheets that are in your
This is free.
your form here, whether you want to come back for other purposes or whether or not you want to be scheduled for the June 9th or June 11th sessions. But
Yeah.
that also should be shared with them on the Mortellaro form.
Yeah, just fill out the form and then someone will call you Monday. You let us know whether you want in person on one of our 2 dates or you want it before then, phone or Zoom.
Right.
Will you be here, Michelangelo, on the 9th and 11th?
Jennifer, am I presenting that day? No. So I will not be on site that day. It'll be one of my employees that will be here. Again, they're all smarter than me and know more. So they can handle anything. But if you want me, a couple of options. Zoom phone is our most efficient. You've already seen this mug. You don't need to see it twice. And if you want, if you do want me and it needs to be in person, what I'll do is I'll just do it next time I'm in the area, which is monthly. I'm in the area for at least a few days during the month. So while I'm here, you know, I'll come by and see you, and then I'll go do a presentation somewhere else if I'm speaking that day. Yes. Yes, sir.
All right. When you're pre-need mortgage, you need somebody outside the family as a backup or whatever. The state, Department of Business and Regulations, or anybody that maintain a list of guardians available for people to stay.
There are licensed professional guardians. Typically, we would refer one to you if you needed one. Most attorneys have a list of professional guardians that they have a good track record and they trust.
So there is a state.
Yeah, they need to be licensed. They're licensed and credentialed and bonded and insured and all that fun stuff. So I don't think that's the way most people find a guardian, because you're just going to see who has a license, and they'll pretty much give anybody a license to practice law in the state. But I'm living proof. But you probably want a referral from somebody who has used them and can tell you they're good.
Well, I was wondering if there's like a yellow pages somewhere online or whatever where we can go and interview the people we need.
No, not that I know of. Not as far as like a referral service, but like, again, we can refer you to a couple and set those up.
Well, thank you so much.
Thank you.
What a great job.
Thank you, sir. Appreciate it. Hi, Michelangelo Mortellaro, estate planning, elder law, and asset protection attorney here. I just had the opportunity to do a presentation at Alderman Oaks in the heart of Sarasota. Hadn't been here before, but it is a great community. They offer independent living and assisted living for seniors here in the Sarasota area. So if you are in the market for senior living solutions, I highly recommend that you check them out. Conveniently located, it's a really nice facility, and they have me in here doing some educational materials. So if you missed my presentation today, we have 2 other times where we're going to be back in to talk about wills and trusts, talk about veterans benefits, and I'll come back and talk about our 5 advanced directives in the future as well. So stay tuned and get a hold of Alderman Oaks. They'll tell you when I'm going to be back here presenting and providing educational content. And while you're here, grab lunch, check out the place, and whether you're in the market for senior living right now or just maybe as a plan B for down the road if you ever need it, I always recommend to my families that you tour communities and you have a hit list of where you would like to go if and when the time comes that you need a custodial care community and you no longer want to deal with living at home and cutting the grass and doing all the stuff that you might be doing now. This may be a great solution for you. One of the things that we offer at Mortellaro Law is free consultations. And that may be foreign to many folks who have dealt with lawyers in the past because most lawyers want to charge for every minute of their day. But we find ourselves, and we pride ourselves on being educators first. And the only way that we can educate you on kind of where you're at on your estate planning journey and where might be a better place to be is through a good old-fashioned conversation. So we offer free consultations to talk about wills and trusts and maybe getting older and needing care. We also will provide free document review for you. So if you have existing estate planning documents from Florida, outside of Florida, new ones, old ones, or anywhere in between, we will take a look at them, we'll evaluate them and tell you if they're awesome, great. You got a second opinion that what you have is exactly what you need. If they're less than awesome, you have the opportunity for us to point out where improvements might be. Whether you use my firm or any other firm, at least you will leave the consultation with more knowledge and more education than when you came in. That is my goal. You can always find us on the web at www.mortellarolaw.com. Bam. And we are also on Facebook, Instagram. TikTok is probably our most popular platform, so search Mortellaro_law if you're on TikTok, and you will see thousands of my custom videos answering questions from the general public and presenting topics on estate planning, elder law, and asset protection. You can always Always also call the office directly at area code 813-367-1500. That is a Tampa number, but we do have offices all across the state of Florida to serve your needs from Key West to Pensacola. Thanks.